Hello, guys. It is Tuesday afternoon. It's about 1 o'clock, and I'm gonna try to make this video before I start feeling bad again. While the medication's still working. So I'm gonna hopefully you won't have any problems. I'm sorry about yesterday. I'm gonna put him back up on YouTube because I think that's easier for us. So I don't know what Canvas is doing. So we today are gonna go through here we go. I think you can see it, 18.3, okay? So we're gonna look at 18.3, which is the Supreme Court, and I will probably also stop it, and then I'll put up another one for 18.4, which is actually kind of shorter, so you could actually go through both of them if you want and be done with it. But let's see how it goes. Okay, so the Supreme Court, what's the concept of judicial review? What does that mean? We're going to talk about that. What is the scope of the Supreme Court's jurisdiction? How do cases reach the Supreme Court? And how does the Supreme Court operate? Okay, so this is actually a little bit longer of a section. It might take us a little bit longer, but we'll see. All right, so there's the Supreme Court. Beautiful building in Washington, D.C. It was actually built during the Great Depression, so they were able to return some money to the federal treasury, like $100,000, which is unheard of, I guess, if you're building a federal building or anything like that. Okay, let me see. Let me keep going here. So it is called the Court of Last Resort. So it's the highest court in the country. And I think I've told you the joke that when I went there to visit and I went in the Supreme Court, they said, actually, it's not the highest court. And the docents, and I said, what do you mean? Or I didn't say what you mean. Everybody said that. And they said, well, right above where we're sitting is a basketball court. So I guess there's a gym on top of the Supreme Court, where sometimes I guess it's more of the clerks than the Supreme Court justices that will go out in there and play. But so that's the big joke, that the highest court in the land is the basketball court that's on top of the Supreme Court. So there you go. Government funnies for today. All right. The Supreme Court has the power of judicial review, which means they can say if something is constitutional or not. All right, so the power to declare acts of government unconstitutional, thus eliminating them, that's what judicial review is. Okay, acts of the government, that could be the president, executive actions, or it could be the Congress with some of the laws they pass. Either or could be considered to be unconstitutional and they'll remove them. So, and it all comes from Marbury v. Madison, which you guys have heard me talk about that before. That set the precedent for judicial review. Hang on. Okay. So let's talk about Marbury versus Madison, because you may not completely understand it. It's a little bit of a weird case, but let's see if I can explain it well enough for you now. Okay, so what happens is John Adams had just lost the presidential election to Jefferson in 1800. Okay, was not a fan of Thomas Jefferson. Remember, Thomas Jefferson is a Democratic Republican. Adams is a Federalist. Adams, before he goes out, he wants to put a stamp on things, so to speak. And he wants to preserve his legacy by appointing a bunch of people to the judgeships that would be Federalists, because then, they're in there, a lot of them are in there for a long term or life. So he created this load of new judgeships that he was going to do. Well, of course, that didn't make Jefferson's very happy. Because, of course, Adams was going to appoint all Federalist Party members to those new positions. He wasn't going to appoint any Democratic Republicans. So he's kind of doing it as a jab at Jefferson to say, ha, 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 I gotcha, right? Okay, so Jefferson is ticked. He's ticked off at Madison. I mean, sorry, not Madison. He's ticked off at Adams about it. And so he orders his Secretary of State, who happens to be James Madison, okay, the Secretary of State. Yes, he later becomes the president, but James Madison, he says, don't deliver those commissions. And that was the job of the Secretary of State at that point, to deliver those jobs or to make those jobs happen. So Marbury, who was a Federalist, and Marbury was supposed to get, he was supposed to become a justice of the peace. Okay, so he's set to be a judge because of John Adams. He is going to sue Madison for not giving him that commission. Okay, I hope you're following. So again, Adams has lost. He creates all these new judgeships, and he's appointing Federalists to them. Thomas Jefferson, who is the newly elected president, he's not in yet. But when he comes in, he orders his Secretary of State to not deliver those commissions. Marbury, it's called the Midnight Judges. Okay, so right before Adams goes out, he does this. Marbury, who is supposed to get a judgeship as a justice of the peace, sues Madison for not delivering the commission. Okay, we got it? Clear, right? All right. So, now, an act that was passed by Congress in 1789, it was called the Judiciary Act. It gave the Supreme Court what was called original jurisdiction in disputes about judgeships. Okay, remember our 4 types of jurisdiction, right? The Supreme Court only has 2, right? All right, so just remember that. Article 3 of the Constitution gives the Supreme Court appellate jurisdiction in those cases. Okay, so we have a Judiciary Act, a law that is passed by Congress, which goes against the Constitution of the United States. It says it's giving the Supreme Court original jurisdiction, but the Constitution says it gives appellate jurisdiction. And what's the supreme law of the land? The Constitution. Okay, you got that so far? All right, so therefore, the Judiciary Act of 1789 and Marbury's lawsuit are unconstitutional. Okay, unconstitutional, because the Supreme Court does not have original jurisdiction in those cases. It would have appellate jurisdiction. Okay, so this is significant because it's the first time the Supreme Court struck down an act of government as unconstitutional. Okay, so I hope that makes sense. Hopefully it makes a little bit more sense to you how that works. So it was considered unconstitutional because it gave the Supreme Court, the Judiciary Act, gave the Supreme Court original jurisdiction when they should only have appellate jurisdiction. Okay, clear? Clear as mud, right? All right, so the Supreme Court does have original and appellate jurisdiction, but when the Constitution says it has appellate jurisdiction in these cases, that's what it needs to have. The court has original jurisdiction over cases that involve 2 or more states, and all cases that are brought against ambassadors or other public ministers of the government. Ambassadors from foreign countries, things like that. Okay, those are original jurisdictions. Most of the cases that the Supreme Court hears every year are appeals cases. They only maybe hear 1 or 2 cases on original jurisdiction in a term, in a year. Okay, so most of the cases are going to be on appeal from a lower court. Okay, so how does a case actually get to the Supreme Court? For a case to be heard, of the 9 justices, 4 of them have to agree that it should be placed on the court's docket, meaning the docket is kind of like a calendar or their schedule, that this is what they're going to see. Okay, they come by writ of certiorari, writ of cert, you can call it. It's a lot faster. Most cases reach the court via writ of cert, which is an order to a lower court to send a record in a given case for its review. So when they say send a record, we're not talking just about a piece of paper. We're talking about all of the evidence and everything like that, the boxes and boxes and boxes that go with each case. That's a writ of certiorari that would send it up. The other way is through a certificate. When a lower court asks the Supreme Court to certify the answer to a specific question in a matter. Okay, that would be a certificate. Okay, does that make a sense? So the lower court doesn't really know how to rule on it, and so they ask the Supreme Court to certify the answer to the specific question. Okay? I hope you got that. You can pause it if you need to. All right, I'm going to keep going. Appealing a case to the Supreme Court. All right, so this shows you how it goes. Okay, the Supreme Court comes federal district court, federal appeals court to the Supreme Court. Remember, 4 of the justices have to agree to put it on the docket. Okay, they agree to hear the case, or they can send the case back to the lower court to reconsider. Okay, so here's another route to the Supreme Court. So this is what I just talked about: district court, court of appeals, Supreme Court. Well, can also go to the Superior Court. The California, I'm giving you the California example: California Court of Appeals, California Supreme Court, and then to the Supreme Court. Okay, so we do have cases that come through our courts here in California that can go all the way up to the Supreme Court. Okay, one of them that I can think of, a landmark case, is UC Davis versus Bakke. I don't know if anybody's doing that one for their SCOTUS project, but that's a case that came through the courts of California and then went all the way up to the Supreme Court. All right, so how does it operate? The first thing the Supreme Court does is they read briefs. And briefs are brief. They are really brief. They're written documents given to the Supreme Court in support of one side of a case. Okay, and they're provided before the oral arguments are given. When I took school law, I had to write briefs, and they couldn't be more than 1 page. They're single spaced. I think they're still 12-point font. I don't remember, but they are very brief. That you put, that's your argument for your side of the case. Now, amicus curiae briefs are called friend of the court briefs. And these are briefs filed by persons or groups who are not actual parties to a case, but who have a substantial interest in its outcome. So an example of this would be the ACLU, American Civil Liberties Union. Okay, they might not be involved in a case, but they might have a substantial interest in it. So you could say, like, Brown v. Board of Education. Okay, we know what that was about. That was about segregating schools. So that I'm not sure that the ACLU wrote an amicus curiae brief for that, but they could have, in the interest of Brown, in the interest of the kids that were being segregated in schools. That would be a friend of the court brief. The Solicitor General is the officer of the Justice Department. They're usually called the federal government's chief lawyer because he or she is going to represent the national government in the Supreme Court. So if the government has an issue, if it's like, I don't know, US versus Nixon, okay, or whatever, something like that, or US versus whatever, it's going to send their chief lawyer, which is the Solicitor General. The Solicitor General will also file an amicus curiae brief on behalf of the president. So it provides the executive branch's views in different cases. So for instance, when President Obama was in office, the Obergefell versus Hodges, which was the case about gay marriage, he, I believe, filed an amicus curiae brief in that case. Okay, so the Solicitor General would file that on behalf of President Obama. Okay, hopefully that makes sense. Okay, so that's an amicus curiae brief. Okay, part 2 are oral arguments. Now it's really interesting when you go to the Supreme Court. You can't take any pictures. You can't even bring in a cell phone or a camera or anything like that. You can't bring in any electronics at all. So you can bring in a piece of paper and a writing utensil. That's about it. Okay. And that's also what happens. Why, when you see a picture of the Supreme Court in session, you actually only see their right profiles, because the sketch artist that is there, the official sketch artist for the Supreme Court, the Supreme Court justices sit in front of you, and then they sit to the right of the Supreme Court justices and to the left of the crowd that is there, okay, the visitors that are there. So they would only have the right profile of the Supreme Court justices, and they just have to draw it, okay? So during the oral argument, each side in the case gets 30 minutes to address their perspective to the Supreme Court. They stand at a lectern, and the lectern has a light on it. And at 25 minutes, this white light will flash. And then after 5 more minutes, a red light is going to signal the end of the presentation. And it has to stop, even if the lawyer is in mid-sentence. Okay. So no matter what, you have to stop when that red light flashes. Now, part of the oral argument, let me stay on there for a second. The Supreme Court knows all about the case before they actually hear it. So you have to figure, if you're one of the lawyers that's arguing, you're going to be asked more questions than you're going to. I mean, you might present your argument and things like that, but they're going to be just throwing questions at you nonstop because they've read all the case law, they've read all the evidence from the case, and they're going to be asking those lawyers questions. So I mean, it's pretty intense how they do it. Okay, and for 25 minutes, 30 minutes, that's quite a long time to be have questions nailed at you from justices of the Supreme Court. Okay, the third part is the conference. The Chief Justice presides over the conference, and this is just the 9 justices of the Supreme Court. And what's interesting, it's held in private, completely in private. One of the customs they have is that every one of the 9 justices has to speak once before anybody speaks twice. Okay, so that's part of the custom that they have in the Supreme Court, that they would hear from every single one of the justices before anybody jumps in and starts giving their thoughts for a second time. Okay, it's held in private. Approximately a third of the court's decisions are unanimous. That's not very many. Only a third are unanimous. So that means 2/3 of the Supreme Court decisions are divided. That's quite a lot. The reasons why most cases are not unanimous is they're all pretty controversial. Okay. And that's what we've seen in the past on the Supreme Court. A lot of the cases are controversial. A lot of the ones that you guys are doing for your SCOTUS case are controversial. Okay, the trial process at the Supreme Court. Once arguments are over, in the conference, the justices will write opinions on the case. Okay. And each justice chooses which opinion to sign his or her name to. Okay, you're going to need to remember these, okay, these types of opinions. And I'm giving you a huge hint. You better know the difference between all these opinions. Could be an essay question. Okay, the first opinion is a majority opinion. And it is the final decision on the case, and it's signed by at least 5 of the justices. It becomes the precedent for how future similar cases should be decided. So what that means is, after Brown v. Board was decided, any segregation cases, they would look back to Brown v. Board because it was legal precedent for how similar cases of the same nature should be decided. Okay, so that is the majority opinion. All right, here are the 4. Okay, I mean the 3, sorry, the 3 types of opinions, and then it says what a precedent is. So majority opinion, formally called the opinion of the court, announces the court's decision in a case and its reasoning. Concurring opinion, concurrent goes together, right? Concurring opinions are sometimes authored by justices to add or emphasize a point that was not made in the majority opinion. So they agree with the majority opinion, but maybe they agree for different reasons. So they're putting those different reasons into the concurring opinion. And then you have dissenting opinions, and to dissent is to go against, okay? So dissenting opinions are written by those justices who do not agree with the court's majority opinion. Okay, so they would be in the minority, but it is called a dissenting opinion. And then again, the definition of precedent, the majority opinions stand as precedent or examples to be followed in similar cases as they arise in the lower courts or reach the Supreme Court. Okay, so again, you're going to need to know these. I'm going to talk about them a little bit more here, but you're going to need to know this. Okay, so dissenting opinion is written or signed by any justice who disagrees with the majority. They're important too. Okay, and they're important because it can become the logic for a future group of justices to overturn this decision. Let me see. I'm trying to think of other ones that were overturned. Well, we know that like the Dred Scott case was overturned, or Plessy versus Ferguson was overturned, okay, because that was segregation, and that was overturned later on with Brown v. Board of Education. Okay, Plessy versus Ferguson, if you don't remember what that was the one that said separate railroad cars for different races is okay. All right, but then with Brown v. Board, it overturned that. Okay, concurring opinion. Again, it's written by a justice who votes with the majority but disagrees with their reasoning as to why. If a justice has a conflict of interest in a case, he or she may recuse himself or stay off of the case. So let me see. An example of this, I don't know if anybody's doing this case either, but one of the Supreme Court cases said that, like in some HOAs, HOA is, what is it? Homeowners Association. I couldn't remember there for a second, but there were some, in some places, they had written into their bylaws in these areas that they could not sell their house to anybody who was African American. Well, the court got a case like that, and the Supreme Court had to look at it. But what they realized, what a couple of justices realized that they didn't even know, is that their same, although they didn't live in the exact same housing development, the places where they lived had very similar rules like that on the books. So those justices had to recuse themselves from the case in that instance. Okay, so that just gives you an example of one of the reasons why they would have to recuse themselves. And of course, the Supreme Court struck that down, by the way, and said, no, that you can't do that. Okay, let's look at some historical cases. Marbury versus Madison, we know that, establishes judicial review. McCulloch versus Maryland allowed Congress to use implied powers under the necessary and proper clause. That was adding meat to the bone, so to speak. Gibbons versus Ogden in 1824 allowed Congress to regulate trade, commercial clause. Okay, important thing also. Pause it if you need to. Dred Scott versus Sanford. This is the one I just mentioned it a little bit ago, but it said people of African descent imported to the United States were not and could never be considered citizens, okay, which didn't help with the rising tensions as we were moving towards the Civil War. Of course, later on, that was overruled. Plessy v. Ferguson, that was the segregation in the train cars. I just talked about that. And then we have Brown v. Board, which overturned Plessy on the grounds that separate is inherently unequal. And the person who argued Brown v. Board of Education, oh my gosh, Thurgood Marshall. I was just thinking, I just forgot his name. Thurgood Marshall. He argued it in front of the court. And that was before he became a member of the court. He became a member of the court as the first African American on the court. Okay. All right. Here's our current Supreme Court. And they sit from the Chief Justice to the most seniors like this. It goes right, left, right, left, right, left, right, left. So Justice Jackson is our newest justice, okay? Before her was Justice Barrett, okay? Justice Clarence Thomas has actually served on the Supreme Court the longest, even longer than the Chief Justice, but the Chief Justice always has a middle. So when these guys sit in the actual Supreme Court, these five are exactly like that. This guy goes here, Amy Coney Barrett goes over next to him, Kavanaugh goes here, and Jackson goes down there. Okay, so it's very, very formal how they do it, and it's very specific where their seating is. All right, let's talk about them. So this is John Roberts. It's called the Roberts Court right now. He is the Chief Justice. He was appointed by President Bush in 2005. This is President George W. Bush, not H.W. So in 2005, so he's been in close to almost 20 years now, 18 years. He is 67 years old, so he was fairly young when he came in, actually. And he is a conservative, although recently he has been voting both ways, which is interesting. That his reasoning has changed as he has aged. All right, our oldest justice, or our longest serving justice, is Clarence Thomas. He's the second African American appointed to the Supreme Court in 1991. This is by George W. Bush's dad, so H.W. Bush. Okay, so he has been in 91, 2001, 1121. He's been in 31 years now. Okay, that's a long time to serve in the Supreme Court. He is 74 years old, and he is a strong conservative. I've actually heard him deliver an opinion, which is really interesting because he actually doesn't speak that much on the court, which is interesting. He probably does most of his talking in the conference, but not actually when he's in the court. So I was happy actually to hear him deliver an opinion. Okay, this is Samuel Alito, and he was appointed by President Bush in 2006. Okay, so this is younger President Bush. He is 72, and he is also a conservative. Okay, those are the first three. Then we have Sonia Sotomayor. She was appointed by President Obama in 2009. So she hasn't been in that long. 13 years? 13 years? Yeah, 13 years. She is 68 years old, and she is a strong liberal. Then we have Elena Kagan, and she was also appointed by President Obama in 2010. She is 62 years old, and she is a liberal. Okay. Then we have Neil Gorsuch, appointed by President Trump in 2017. He is 55 years old, and he is a conservative. And he's the one that I showed you the picture earlier of, that he was taking the oath of office from Justice Kennedy, because he had actually clerked for him in his early law days. So it was like a kind of a nice rite of passage for him. Okay, then we have Brett Kavanaugh, who was appointed by President Trump in 2018. He is 57, and he is a conservative. Then we have Amy Coney Barrett, who was appointed by President Trump in 2020, and she is 50 years old, and she is also a conservative. I think she's a mom of like 7 or something. I don't know. And I think she has a couple of adopted kids from Haiti. It was impressive with her in her hearing, because they always have a Senate hearing. I was impressed with this when I watched some of it, that she has such a good memory and was able to quote all these things. And somebody asked if they could see her notes, and she held up the paper, and all it said on it was Senate of the United States, and she hadn't even written any notes down. So I wish I could remember that much. And then our newest justice just came in, Justice Ketanji Brown Jackson, and she was appointed this year in 2022. So she just started her term they would have started, I believe, in August. So I think that's just when she started her term, in August, when Stephen Breyer had retired. And she is only 52 years old, and she is a liberal. Okay, and we'll see. We haven't seen any opinions written by her, because the opinions don't come out until the spring. They hear arguments from about October through April, and then they issue their opinions in May and June usually. Okay, so we haven't heard anything yet from Justice Jackson, but I'm sure she'll write either an opinion, a majority opinion, or a dissenting opinion. We'll see. I don't know which court cases they're looking at right now. All right. So the president gives more attention to nominations to the Supreme Court than anything else, okay, because it's higher visibility. They often consider their party affiliation, so which political party, their judicial philosophy, some of the judges that share the same ideology, race, gender, religion, and region, judicial experience, and then the litmus tests. Like they choose a judge based on their view on only one single issue. Like, what's your view on abortion? Okay, that's what we'll choose you on. And then acceptability. They want, because these judges have to be justices, they have to be confirmed by Senate. They usually want an easy confirmation with the Senate. Okay, so that's what they're going to try to search for. All right, so almost all federal judges have had legal training. They've held positions in government before. They've served as lawyers for leading firms. They've served as federal district attorneys. They've served as law school professors. We've had few African Americans, Hispanics, or women. I'm not sure actually if we've had any Asian Americans, which is interesting to me, that it hasn't even been mentioned, I guess, that we haven't had an Asian American on there, which is interesting, because we have Sonia Sotomayor, she's Hispanic. We have, right now we have 1, 2, 3. We have 4 out of the 9 that are women, which is great. We have 2 African Americans on there, which is great right now, and 1 Hispanic on there. But I don't think we have any Asian Americans. President Johnson was the one who appointed our first African American, and that was Thurgood Marshall, who I told you argued the case Brown v. Board of Education before he was on the Supreme Court. President Reagan is the one, and you might have seen this when we went to the Reagan Museum library, but he appointed the first female Supreme Court justice, who was Sandra Day O'Connor, who's done a ton for women in law. I was excited after she retired. She's still alive, but after she had retired from the Supreme Court, one of the days I went in with the kids to hear an opinion read, she showed up as a guest, and I was so excited. And you can't talk in there or anything, so I'm trying to say under my breath, Sandra Day O'Connor, Sandra Day O'Connor, so that the kids around me would look and see her without, making a commotion. But I was very excited to see her because you guys know that if I wasn't a teacher, I'd be a lawyer, right? Because that was the other thing I wanted to do. But I love teaching you guys there. All right, let's look at the Supreme Court through the history. The courts are named after the Chief Justice. So the Warren Court was led by Chief Justice Earl Warren. That's him. That was the 50s and 60s, essentially. It was said to be the most liberal court ever. Here's some of the cases which some of you might be working on. Of course, Brown v. Board is in there. Gideon versus Wainwright. I'm not sure if anybody's doing that for their case. And then we also have Miranda versus Arizona, which I think, William, you're doing this case. Yeah, I think William's doing Miranda versus Arizona. I think somebody is doing Gideon versus Wainwright. I just can't remember who. But those are some of the court cases there. After the Warren Court, we have the Burger Court, which was essentially all the 70s and half of the 80s. And it was led by this guy, Warren Burger. And it brought us back to more conservative ideology. He was appointed by Richard Nixon. And here's some of the important cases. Roe v. Wade, which we now know that has been sent back to the states. And I'll try to explain some of that a little bit later, but it declared abortions legal with special time constraints. And then U.S. versus Nixon, which ruled that President Nixon's private recordings, this is the tapes that he made in the Oval Office of his meetings with people. It was not protected, and that he had to turn those over. That was during the Watergate fiasco. Okay. With Roe v. Wade, essentially what they have just now said with the Dobbs case, which is overturning this, said that the federal government doesn't have the ability to make, or the right to make decisions on medical care for people, which is actually kind of true, because if you think, they said, and that's back to the 10th Amendment to the Constitution, which preserves some of this for states' rights. And basically, like, for instance, you can't get if you're ill with cancer and there's no cure for you and you're going to die, there are some states that you can go to and you can get assisted in dying earlier, so you don't have to go through all of the all of the hard times of the actual dying process. Okay, so if you have terminal cancer and things like that, so there are some states you can go to that will do, I can't remember what the term is, but they'll assist you in ending your life early. Not all states have that. Only some states have that. So people literally will travel to those states that do have that so that they can not suffer in the last days and not have to put their family through that. Okay, it's the same thing with Roe v. Wade, where they said it's not the federal government's position. This is a states' rights thing. And so it's actually there, if you actually read the whole Dobbs thing, which is really long to read, and nobody's doing that one for this, but it actually goes through why that would be more of a state's right instead of a federal government's right. So it's actually putting more rights back to the people, because you can affect more change at your state level than you can at the federal level. I don't know if that makes sense. I'm hoping you understand that. I've had some conversations with some lawyers about this and explaining it to me and everything. It's a little bit more in depth than that, but I'm trying to give you the basics. Okay, let me keep going. Rehnquist Court, 86 to 2005. So half of the 80s, all of the 90s, and half of 2000 to 2005. This is Chief Justice William Rehnquist. It was a conservative court that continued to limit but not reverse decisions of earlier, more liberal courts. Okay. And some of the important cases were Planned Parenthood versus Casey and Roper versus Simmons. Okay. Planned Parenthood versus Casey said that a Pennsylvania law, it upheld and it ruled constitutional that a Pennsylvania law requiring a minor to wait 24 hours after receiving parental approval before getting an abortion. But so they agreed with part of it, but they disagreed with other part of it. But they ruled unconstitutional a provision that required a woman to obtain informed spousal consent before having abortion. So that means they didn't have to get the permission of the father before they had that. Okay. And then Roper v. Simmons, I'm not sure if somebody's doing this one, but it declared that the death penalty was unconstitutional for minors, for anyone under the age of 18. So when that happened, it actually released a bunch of people. Okay. So in your journal, I want you to journal this, okay? And you can put today's date, which is December 7, Pearl Harbor Day, okay? What do you think is the hardest part of being a justice in the Supreme Court? Okay. If you were a justice, how would you approach constitutional issues such as abortion, gun ownership, gay marriage? I know it says here to write it on canvas. I want you to just go ahead and write it in your journal. Okay, so just write this in your journal, your actual journal of notes. Just pull it out and go ahead and write in there. Okay. All right. I am going to stop my screen share and let you guys finish that and stop recording, and hopefully this will be up for you soon. Okay. All right. See you.